Good morning, everybody. Thank you for joining today. We have a really exciting top presenter today and presenters we want to get to as soon as possible. Of course, a really important topic, part of our health advocacy series. I now want to turn it over to Dr. Salas. Dr. Salas, thanks so much for hosting today's Grand Rounds and introducing Dr. Myler, and also Dr. Amila, who will be speaking as well. I'll turn it over to you. Thanks so much.
Thank you, Errol. Dr. Hidalgo, thank you for putting together this series on public health crises, and it's an honor to be helping and be part of that today. Before we get into the introductions for our speakers, just an announcement of upcoming Grand Rounds. We have next week our third in this series of public health Grand Rounds on reducing firearm injury and death, what clinicians can do with Drs. Parsonet, Barnhorst, and Studdert. And then August 3rd, the week after, we are having our in-person Grand Rounds, the first of the month, unless that changes. Keep an eye on your emails. And our guest will be Dr. McCullough West, who is an acute and critical care surgeon, who's going to be talking to us about transforming healthcare, transgender healthcare. So with no further ado, I'd love to go ahead and introduce our speakers. Our main speaker this morning is Bernadette Myler, who is the Carl and Sheila Spaeth Professor of Law and Professor by Courtesy of English and Comparative Literature and Associate Dean for Research here at Stanford Law School. She researches and teaches in the areas of constitutional law, legal history, and law and literature. Her publications include articles in the Stanford, UCLA, Southern California, and Cornell Law Reviews, as well as a variety of peer-reviewed journals. Professor Myler also authored Theaters of Pardoning in 2019 and co-edited the Oxford Handbook of Law and the Humanities in 2020, as well as New Directions in Law and Literature in 2017. She is a 2020 or was a 2020 Guggenheim Fellow in Constitutional Studies and taught at Cornell and Princeton universities before coming to Stanford. Professor Myler received her JD from Stanford Law School, and she also has earned a PhD in English at University of California in Irvine and an AB magna cum laude from Harvard University. Prior to entering academia, she clerked for Judge Robert A. Katzman on the U.S. Court of Appeals for the Second Circuit. And I want to add that she's really a pioneer in the intersections of law and the humanities, being maybe the only person, I'm not sure, to have doctoral degrees, essentially, postgraduate degrees in both of those fields. We're so lucky to have her joining us today, talking about some of the implications of overturning Roe versus Wade with the Dobbs decision that came out recently. So with no further ado, I'd like to turn it over to Professor Myler. Thank you so much for joining us this morning.
Thank you so much, Dr. Salas, and also Dr. Hidalgo for inviting me to speak about this set of really important topics. And I will go ahead and share my screen with some PowerPoint for the presentation. So my topic today is thinking about what happens after Roe and in the aftermath of the Dobbs decision just released by the Supreme Court. And today I will be thinking about a couple of different issues with you, and I want to leave enough time for Q&A, so I will try to keep my remarks to only around a half hour or so. But first of all, I want to give you a little bit of an outline of how we got here. So what happened in Roe v. Wade half a century ago itself, and what happened after that to lead to the decision by the Supreme Court in the Dobbs case. Then the second thing I want to do is to give you a little bit more from a legal perspective about what Dobbs actually did and what it said and the rationale, as well as the ways in which we might think about the implications of Dobbs and what it doesn't do. Then the third set of issues I want to really discuss with you is the kinds of complications that the Dobbs case set up or set us up for. Dobbs itself says, oh, well, the court is getting out of the business of policing abortion, it's leaving it to the states. But actually, by leaving it to the states, it's led to a number of different issues and complications that are going to be percolating through the courts as well as through state executive and legislative branches for perhaps years to come. So without further ado, let me go into sort of the setting the stage about Roe. So half a century ago, almost, we had the decision in Roe v. Wade. And as you know, that protected the right to choose an abortion, a woman's right to choose an abortion, as well as a doctor's right to perform an abortion. And the rationale there was that the right to choose an abortion should be protected as part of a fundamental right to privacy under the Constitution. There had been some question about where in the Constitution this right might be located, but ultimately the court in Roe said that it was part of the due process clause of the 14th Amendment. And just for background, the 14th Amendment says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. So it's this part about not depriving any person of life, liberty, or property without due process of law that is the basis for the right to privacy articulated in Roe, and that supports the right to abortion under Roe. The court in Roe also made a couple of other statements. So one thing that the court noted was that historically, abortion hadn't been restricted for at least as significantly as it was at the time of Roe for quite a while. One thing the court says is it is perhaps not generally appreciated that the restrictive criminal abortion laws in effect in a majority of states today are of relatively recent vintage. Those laws, generally proscribing abortion or its attempt at any time during pregnancy, except when necessary to preserve the pregnant woman's life, are not of ancient or even of common law origin. Instead, they derive from statutory changes effected for the most part in the latter half of the 19th century. So in Roe, the court really goes into the fact that at common law, which is the legal system kind of preceding the Constitution in England and America, most abortions were okay before what was called quickening, which was supposed to be when a woman could feel a fetus moving. So before quickening, abortion was acceptable under the common law, but then in the 19th century, a number of states started passing statutes for various reasons, perhaps to enforce Victorian ideas of morality, that then criminalized abortion at any time. What is also noteworthy about Roe is that it has set up this framework of trimesters. So saying that in the first trimester, there could be virtually no restrictions on abortion. And then in the second trimester, there could be restrictions that had to do with the safeguarding the health of the mother and maintaining medical standards. And then in the third trimester, that the state's interest in preserving the potential life became compelling. So this was the framework that Roe set up. One final thing to note here is that the court in Roe expressed a lot of deference to medical judgment. The court wanted to make sure that medical judgment and not the judgment of legislators was the dominant factor in the decision about abortions. And so that was one part of the emphasis of the court in the Roe case. Now, moving on, we move on about 20 years and we get the case of Planned Parenthood against Casey. And that substantially changed Roe, although it said that it was reaffirming the central holding of Roe. So in Casey, the court abandoned the trimester framework and also focused on liberty instead of privacy, so the liberty of the mother. And that was partly because that's more, that was perceived as more textually grounded in the 14th Amendment, which explicitly refers to liberty. And what the court in Casey said was that states couldn't impose, or even the federal government couldn't impose, an undue burden on a woman's right to choose an abortion before viability. Now, of course, that line of viability might be a shifting line depending on the advances in medical technology. But what the court said in terms of defining the undue burden standard was that an undue burden exists, and therefore a provision of law is invalid if its purpose or effect is to place substantial obstacles in the path of a woman seeking an abortion before the fetus attains viability. So the idea was that you couldn't put a substantial obstacle in the path of a woman's efforts to obtain an abortion before viability. Now, that still allowed a number of restrictions to be upheld by the court. And we see in the time between Casey and today, a number of states really pushing the boundaries of what the Casey court was allowing. And then eventually these cases wound up in the Supreme Court. So just to give you an outline of a couple of the kinds of restrictions that happened in the aftermath of Casey, and that were sometimes upheld, sometimes not upheld, or sometimes didn't even make it to the Supreme Court. In 2003, Congress passed the federal partial birth abortion ban, and that was designed to target a particular method of performing abortion. So it didn't target all late-stage abortions, but rather a particular method that had come to be called politically a partial birth abortion. And that was upheld because it had sufficient exceptions according to the Supreme Court. Then there were a number of different kinds of state efforts to restrict abortion. So one kind had to do with requiring hospital admitting privileges within a certain distance from an abortion clinic, or different kinds of statutes tried to define when life began. And this is noteworthy because the court in Roe had said, we're not going to get into the business of saying when life begins. That's a question for priests or for religious figures rather than for a court. But some state statutes tried to define when life began, and even say that fetuses were persons who were deserving of protection under the 14th Amendment itself. Then there were other kinds of requirements like waiting periods, so requiring that a woman go and receive counseling about abortion and then come back a day later to actually receive the abortion if she still wanted to. Most recently, there was a very different kind of law passed in Texas called SB 8. And that law was different because it wasn't a law that allowed the state to prosecute people. Instead, it gave the power to individual citizens to sue anyone who helped a woman obtain an abortion or who was a doctor performing an abortion. And it allowed for substantial civil liability. So what this meant is that then people were kind of deterred from performing abortions because of the threat of civil liability and of damages. And that law is actually a model for some that are going forward after Dobbs as well. So I will get to that in a moment. Now, this sort of sets the stage for the Dobbs decision itself earlier this summer. So just to also give you some sort of sense of this, a lot of the Supreme Court nomination process in the half century since Roe was significantly affected by Roe itself. So almost every Supreme Court candidate had to come up with a kind of answer skirting around whether they would decide one way or another on Roe. And there were various efforts to pin candidates down about their position on it. And a lot of the momentum behind replacing, say, Justice Ginsburg very quickly was caused by the effort to overturn Roe. So, part of how we got here is through a very politicized Supreme Court nomination process. So the majority opinion in the Dobbs case, which relied on many of the new members of the court, overturned Roe. And it overturned Roe in a very thoroughgoing and dramatic way, not in a limited way. So Justice Alito said that there was no right to privacy in the text of the Constitution. And he said, well, there might be some fundamental rights that are protected under the Constitution, even though they're not part of a right to privacy. And those kinds of rights are rights that are part of a set of fundamental rights that are deeply rooted in history and tradition and essential to our concept of ordered liberty. So just to give you an example of where that kind of reasoning comes from, another earlier case decided by Justice Scalia dealt with the rights of non-marital fathers. And so there was a father who was claiming some rights of visitation over a child whom he had fathered while having an affair with a married woman. And Justice Scalia said, well, it doesn't matter that there's a DNA test proving that he's the father. Under the deeply rooted history and traditions in going back to England, there weren't rights of non-marital fathers because of various property issues and property arrangements. So he kind of ignored the developments in technology that allowed for us to know whether someone is a non-marital father or not, and instead said there's no deeply rooted right of a non-marital father to access some kind of care over a child, so therefore there is no right in this case. So that way of thinking about rights is consistent with how rights were thought about in Dobbs, rather than saying in a broader way, well, are there rights of fathers generally in the tradition that we can then extend to non-marital fathers given new technology? He said, no, there's no specific narrow right of a non-marital father. Similarly, in Dobbs, Justice Alito says, well, in order to have a right to an abortion, we would have to see specific protections for that abortion right, not protections for some more general right to bodily autonomy or to decisions about procreation. We have to see a specific right for abortion. And he looks at these 19th century state statutes that prohibited abortion and says, well, we see that those prohibited abortion, so there's no constitutional right to an abortion here. Now, there's also something strange about this logic, given that these state statutes were passed when women couldn't vote, and before the 19th Amendment gave women the right to vote on the federal level as well. So there's this significant omission of really consideration of that in the decision, as well as omission of any consideration of the Equal Protection Clause of the 14th Amendment, which Alito says an earlier case kind of forecloses using in this regard. So that's the basic outline of the Dobbs case and what happened in Dobbs. And of course, I'm happy to discuss it in more detail in Q&A as well. What I want to note before leaving Dobbs is that there were several important concurrences in the opinion. So these are people who either joined the majority or joined the decision of the court, but wanted to weigh in about separate reasoning. And the reason these are important is that they foreshadow some things that might happen in the future, or ways that there might be certain other developments with respect to abortion, but also with respect to other kinds of rights. So Justice Thomas wrote a concurrence that suggested that all of the cases involving liberty and privacy that had dealt with contraception, sodomy, same-sex marriage should all be overturned in the wake of the Dobbs decision. And Justice Alito's majority opinion kind of disclaimed overturning other non-abortion related decisions, but the logic, I think, if you follow the logic of his opinion, it suggests that a lot of these other cases could be subject to revisiting as well. Most notably, I would say that the Roe decision itself relied on earlier cases about access to contraception, where the whole idea of a right to privacy came up in the context of the assertion of a right to access to contraception, and the Roe decision builds on that logic. So I think that that would be the logical next step for the court if they're thinking about overturning some other kinds of rights. And we already see some states trying to move to restrict access to IUDs and other kinds of contraception. Now, Justice Kavanaugh also had a concurrence, and his concurrence is also noteworthy because it seems to try to limit a bit how far the court's decision is going. So Justice Alito himself said that he was throwing the decision about abortion back to the states. So it wasn't that he's overturning the right to abortion generally in the country, but rather throwing the decision about the legality of abortion back to the states. Now, Kavanaugh outlined where he sees some limitations on that effort to throw things back to the states. And he in particular said that he thinks that women retain a right to travel interstate to obtain abortions in the wake of this decision. And there is a lot of case law about the right to travel in various other areas, which is grounded in the Privileges and Immunities Clause of the Constitution. And but there are also questions about the scope of that right to travel. So, you know, I think that there definitely is a right to travel to obtain an abortion in the wake of this decision, but there will still be questions about the right, the scope of that right. Then finally, just, you know, sort of to indicate another possible way the case could have come out, Chief Justice Roberts also had a concurrence, and his concurrence suggested that he would have actually upheld the statute as well, but on more limited grounds, and would have taken a more incremental approach, which is sort of the approach that the court had taken in the past 2 decades towards limiting abortion as well. So this brings us to a number of different complications after Dobbs. And the first one has to do with the ability to access abortion interstate. And this raises a whole host of federalism questions and problems. So as I mentioned, there is this right to travel. So people have a right to travel between states and to move to another state. And so that, you know, there may be some questions of what happens once they go back to their original state, but there is a right to travel to obtain abortions. Now, there are also these efforts ongoing in various states that are restricting abortion to criminalize abortion and to also, you know, try to create civil liability along the lines of Texas's SB 8, not only against women who are obtaining abortions, but also against providers and third parties who are assisting them in that effort. Now, a lot of the movement so far has been along the lines of the Texas SB 8, trying to create civil liability and civil penalties for people who are assisting in performing abortion. So let me just give you an example. What if someone in Arizona comes to California and tries to obtain an abortion, then goes back to Arizona? Would Arizona be able to reach out to the doctor who performed the abortion in California and have, say, the woman's husband sue the doctor for performing the abortion and get a judgment in Arizona? So this raises a whole host of questions. So first of all, probably under that scenario, the court wouldn't have jurisdiction over the doctor because the doctor hadn't done anything to kind of reach out and say, in Arizona, look, my services are available. If you come here, I will, you know, provide an abortion. However, if we start thinking like, well, what if organizations do reach out into states that are not providing abortions, maybe then they would be able to establish enough ties that a state would have jurisdiction over them. Then the other question is, you know, what's the choice of law in those states? So that's another murky question. Is it going to be Arizona law that controls or California law that controls? Then the final one, and this is something that California has actually sort of anticipated and tried to deal with already in anticipation is what happens if an Arizona court reaches a judgment, say, against a doctor in California, and then they want to enforce the judgment through a California court. What happens in that case? Now, that raises this issue about what's called the full faith and credit clause. Under the Constitution, courts in one state are supposed to give full faith and credit to judgments of courts in other states. Now, in AB 1666, California has said, we will not honor judgments against women or doctors from other states that are trying to prohibit abortion. It's not entirely clear how much, whether that's constitutional. I think it may or may not be. And there are various ways in which there have been public policy exceptions to full faith and credit, but it's a complicated legal question that will definitely be something that's going to be adjudicated in the future. Now, another issue that kind of comes up as well is the potential for kind of criminal prosecution. In general, that's probably going to be less of an issue, especially if someone is providing out of state, because you're supposed to, under the Sixth Amendment, be able to be tried in the vicinity of a crime if it wouldn't be a crime in the state that it was occurring. So those are some of the kind of complications here involving interstate abortion access. And then the other part about that is that I think, California has, along the lines of what it's done in the climate area, already started engaging in some agreements with other states that are similarly minded to try to kind of come up with an alliance of states that would be able to work together to provide access to abortion care. Now, another issue that has come up is the federal guidance and FDA orders about the availability of medication abortions and mifepristone. So under COVID, there had been a kind of exception to or an extension of availability of medication abortions by mail because of issues with provision under COVID. And then that was extended pre-Dobbs to just be indefinitely available. So at this point, medication abortions are available from other states and can be mailed. Pharmacies can prescribe and then mail medication to a different state. Now, this particular guidance raises some questions about what's called preemption. So federal law, generally, if it's passed under one of the enumerated provisions of the Constitution, whether the Commerce Power or the Spending Clause or something else, is going to preempt state law that goes against it. Now, the question is, will the FDA guidance preempt state law in states that are restricting abortions? It's clearly preempting a contrary state judgment about the safety and efficacy of medication abortions, because that's the premise of the FDA order. But it's not 100% clear if it's preempting state law that would be on a different basis. And there's already a kind of ongoing case that preceded Dobbs that is coming out of Mississippi called Gen BioPro against Dobbs. And that case is dealing with exactly this question of whether the FDA guidance preempts contrary state law. And there are also some issues that I think my colleague Michelle Mello may address about pharmacists' refusal to prescribe medication abortions as well. There's also, there was a recent order under July 8th, President Biden made an order that was about trying to implement more protections on the federal level for abortion access. So it talks about access to emergency care, access to medication abortions, and data privacy. And also he's been asking the DOJ to investigate any kind of violations of access to emergency care. Just to flag one issue on the emergency care front, a number of the state statutes that have been passed prohibiting abortion have exceptions for the life of the mother, but it's really unclear how far those go. And so the emergency care exception also, there's a question about how emergency is defined, right? So is it an emergency if someone has to forego cancer treatment because they can't obtain an abortion, or is that not a sufficient emergency, or is that not sufficiently endangering the health of the mother? Now, then there's a question about what kind of federal legislation could be passed. There have been efforts by the House to pass some legislation. Those have been stymied in the Senate. There's also, a question if the politics changes in the future years, whether there would be a national ban on abortion as well. So the thing to note about federal legislation is it has to be grounded in one of the clauses of the Constitution that gives Congress power. The 14th Amendment would be foreclosed because the court has said that this right is not grounded in the 14th Amendment, and other cases say that Congress can't legislate more than the court thinks would be necessary under a provision like that. Now, most of the legislation that we see is under the commerce power, so the power to regulate commerce between the states. So a lot of this could be done under the commerce power. Also, the power of spending. So the federal government has the power to spend for the public welfare and for the general welfare. And so Medicaid is premised on that. So conditions on Medicaid spending might be effective as well. So those are some other parts of the complications here. Now, the final set of complications I just wanted to flag has to do with the scope of the Dobbs opinion and whether it implicates other areas, as I mentioned. Now, I think that there is the potential for overturning these cases that establish a 14th Amendment right to access contraception. And already states have started trying to legislate to restrict availability of Plan B as well as intrauterine devices on the grounds that they may have abortifacient effects. Now, I think there will be ongoing litigation about the extent to which contraception access continues to be protected after the Dobbs decision. Now, the other set of cases I would say that I think are really implicated by Dobbs have to do with sexual autonomy. So the case Lawrence against Texas, which said that there could be no ban in Texas on same-sex sodomy because that was interfering with relational autonomy and privacy under the Constitution, as well as the cases that establish a fundamental right to same-sex marriage. Those cases could also be in the line of fire, especially under Justice Thomas's concurrence in the case, but also under the logic of the Dobbs opinion itself, in that none of these practices were protected in the 19th century in the way that abortion also wasn't protected. So with that, I think I would like to leave it open for Q&A, and I will stop sharing my screen now. Thank you so much, and I'm really looking forward to talking with you about any questions you have.
Oh, thank you so much, Professor Milo. That was super informative. At this point, what I'd like to do is to welcome Michelle Mello. So folks, we're lucky to have Michelle Mello joining us for the discussion portion of today's session. So I'm going to do a quick brief introduction for her. Michelle Mello is a professor of law at Stanford Law School and professor of health policy here at the School of Medicine. She conducts empirical research into issues at the intersection of law, ethics, and health policy, and examines legal developments relating to public health issues. She's a member of the National Academy of Medicine and holds a PhD in health policy and administration from the University of North Carolina at Chapel Hill, in addition to her law degree from Yale. Thank you so much for joining us, Professor Mello. I thought we might just start off with what you had alluded to earlier, Professor Myler, about pharmacists and what's happening, what we're hearing reports of related to refusing to fill prescriptions. Professor Miller, would you mind sharing your insights on what's happening now and what we think is likely to be the durable impact of the Dobbs decision as relates to pharmaceuticals?
Yeah, so I think Bernie provided some really helpful background regarding that FDA guidance on the cross-state prescriptions for medication abortion. But there's another wrinkle that has emerged over the last few weeks that many of you are probably aware of regarding pharmacists, and that is that a lot of pharmacists in abortion restrictive states have reportedly been denying medications to patients who need them for reasons other than inducing an abortion because the patient is apparently a woman of childbearing age and the drug has this other use. The Biden administration has addressed that recently with guidance to pharmacists that attempts to use federal anti-discrimination law as a tool to reinforce to pharmacists that that behavior is illegal under federal law. So the take home for clinicians, I'm happy to go into the legal details, but I think the take home for clinicians is if you've got a patient who's being denied methotrexate or either of the other abortifacient drugs, and that patient is not seeking them to induce abortion, but rather to treat, for example, complications of a spontaneous pregnancy loss or to treat rheumatoid arthritis or any other indication, this guidance document can be pretty helpful in clarifying to pharmacists that that denial is illegal. And I'll put the link to that guidance in the chat to Dr. Salas so she can pass that along. What's going on here might be a couple of things. Maybe pharmacists are zealots and are taking this like open door as an opportunity to kick the door open even further and shut down access to these medications in conformance with their conscience. But as a health law scholar, I think more likely what's going on here is people are freaked out and uncertain about their obligations post-Dobbs, and they haven't been getting the kind of legal advice that they need to understand that states are not trying to prohibit the provision of these drugs in these kinds of cases where it is not being used for abortion. I think whether the federal guidance will be successful in using anti-discrimination law to go after that practice is an open question. It's not clear cut. But what would be super helpful would be for pharmacist associations, hospital attorneys, and others to clarify for their members and staff that this is not legally required of them. It's that legal uncertainty that's likely to sweep in a lot of people as collateral damage in this fight.
Well, and in the meantime, while folks are sorting out whether they should or shouldn't fill these prescriptions, there are people who are losing access to medications that they need for their healthcare that may be completely unrelated to abortion. One related question I have for you, Professor Mello, before we go into the questions, the really excellent questions that are popping into the Q&A, kind of dovetails with what you were just talking about. I've heard reports of healthcare workers feeling that they are now mandatory in those in particular states for now, that they feel they are mandatory reporters of patients who are seeking abortions. And I wonder if you could help us understand with relation to HIPAA, what the responsibility is for folks who are caring for patients seeking abortion, particularly in states that have enacted or are going to be enacting restrictions to abortion access.
Yeah, I'm glad you asked that because I think this is an area where the law is just really misunderstood, and the Biden administration's recent attempt to clarify it, I think, has fallen flat. Even among people who know something about HIPAA, there's still some misunderstanding. It is the case that I think most states now require some kind of reporting when abortion services are provided. It doesn't necessarily involve the patient's identifying information. It doesn't always, but sometimes does require reporting of the reason for the abortion service being provided. But those obligations exist under state law. So the question is, what happens when HIPAA is relevant, as it always is in the context of healthcare provision. One might think, well, this is a federal law, we're talking state law, so doesn't it trump the state law obligations? HIPAA has anticipated a variety of interactions with state law and has dealt with them in kind of different ways, but the long and short of it is, if you're in a state that requires you to report that information, you can't wield HIPAA as a reason not to comply with that obligation. You are unfortunately still subject to state law. However, you cannot, under HIPAA, just decide to report a patient to law enforcement because she or they have sought an abortion-related service or asked questions about abortion. That's a disclosure that's not required by state law, and that kind of sua sponte disclosure is prohibited by HIPAA.
That's very helpful. So if I got that right, what you're saying is if the person is practicing in a state where there's a specific law that says they have to report, then they have to report. But lacking that, there is no duty to report.
Yeah, that's right. And let me just clarify
violation.
one other thing. And that is, like, when I'm talking about these reporting laws, they're generally coming out of state public health departments, and they're collecting data. What we should think about separately is a request by law enforcement or a private citizen that's trying to bring the kind of civil lawsuit that Bernie talked about as part of Texas's SB 8. That's separate. And in order to get that, for those types of people that get the information, they're looking for patient-specific information more than likely. They need an investigative demand of some kind, a warrant, an administrative subpoena, and it has to follow due process. There's also an applicable privilege, the physician-patient privilege, that might be helpful in resisting those kinds of demands. So the long and short of it is, if it's that kind of request, not a report to the state per se, but a response concerning a specific effort to enforce state law, the best thing to do is consult counsel and ask, hey, is there a possibility of asserting this physician-patient privilege here? The answer to that's going to vary from state to state.
Yeah, to me, one of the take homes is that this is just reverting to states' rights, as they've said, is just causing so much difficulty for folks to understand what is supposed to be happening, what they're allowed to do for healthcare workers, what we're allowed to do, what we're not allowed to do. It's just causing a lot of confusion, which ultimately is likely to harm patients.
That's right. And if there's one thing we know about physicians is that very risk-averse creatures when it comes to legal liability. And so I think this is really a time, again, to come together with trusted legal advisors and ask, before you decide that you can't help out a patient in particular circumstances, ask, what are the tools that are available to us? What can we do to push back, at least make it harder on the law enforcer that's seeking this information?
Yeah, and that's a great point too, because it brings up some of the things we were seeing in social media related to what Professor Myler was saying earlier too about emergency. What constitutes an emergency? If you're in a state, if you're practicing in a state that has restrictions in place currently, and a patient shows up to your emergency room or to your office or on your hospital, and as a provider or a practitioner that the right thing for this patient is an abortion, but you're in a state that doesn't allow that, at what point will folks feel like they are justified in saying, no, this really is an emergency? Is it, that the patient is likely to die within the next day, within the next week, within the next hour? What does that mean? And to me, that's a disconnect between legislators who maybe don't understand the nuances of clinical care. And then those of us who are out there caring for patients are stuck figuring out how to provide care for our patients, but also, as you said, protect ourselves. Because if we get taken out of the system because somebody prosecutes us, we're not helping anybody.
And that's another area that the Biden administration has tried to address. They're very aware of this problem that Lisa Harris and others have been writing about in pretty high profile places. So there's some guidance that came out last week on EMTALA, the federal law that requires hospitals that participate in Medicare and Medicaid to render stabilizing treatment in emergency contexts. And that guidance says explicitly, it is up to the care team to determine what constitutes an emergency and what constitutes appropriate stabilizing treatment, period. It's also the position of the Biden administration that this aspect of federal law trumps any conflicting state law. And I think they're probably right about that. I think it is pretty clear that that's the case. So again, hopefully this clarification makes providers feel a little bit more comfortable doing what they always do, which is make decisions about appropriate care based on clinical considerations only.
That's very helpful. Thank you for walking us through all of that. I'd like to go now to our Vice Chair of Finance, Kathy Garcio, for a question.
Thank you. Thanks, Argavon. I guess, Professor Myler, I wondered if you could just comment a little bit, given what Professor Mello just said as well. Could you comment on the Texas Attorney General's recent attempt to sue the federal government for insisting that emergencies be treated as emergencies in hospitals that accept federal payments?
Yes, I think this is exactly the kind of lawsuit that we're going to see a lot more of as we go forward. So part of what is at issue, there are a couple of different issues here. So a lot of it has to do with what I was mentioning about preemption, and then also what Professor Mello was saying about that, whether or not federal law trumps state law. And there, in general, when you're looking at that, they look to whether congressional intent means that Congress intended to trump state law with what it was passing. So was Congress intending to supersede state law, or was it leaving room for the states to do something? Now, there's another kind of complication, which is that sometimes there will be a claim that the executive or the president or administrative agencies have gone beyond what Congress intended. And so this is something that happened with the COVID mask mandates, right? That this idea that, maybe there's, some kind of statute, but it's not sufficiently tied to the guidance that the executive, the president is giving, or Health and Human Services is giving. And so therefore, there isn't authorization under the statute for going this far. So I think that those are the two kind of basic arguments that are going to be made going forward about why the emergency provisions that Biden is focusing on shouldn't trump contrary state law.
Yeah, it's certainly just helps us to see more and more of the types of uncertainty that we're going to be facing in the coming weeks, months, and probably years. I want to go to another question that this one's from the Q&A about, essentially my paraphrasing is, why in the world is the government trying to legislate abortion? The actual question as written is, what is the argument that the state has a responsibility to regulate abortion? It seems like maybe they're arguing that abortion is murder. What is the argument behind that? And are those arguments religious? If so, are we seeing a violation of the separation of church and state?
Yeah, so I think that there have been some very interesting arguments against Dobbs from a religious perspective. Actually, I just want to flag that there have been some efforts to say that actually the decision is violating some people's free exercise of religion because it puts the life of a mother or the health of a mother in conflict with fetal life and will restrict access to healthcare for women. But more broadly, I would say that by throwing this back to the states basically have a plenary power under what's thought of as like the police powers of the state to define what they think of as criminal or not criminal. So, we could have states change the definition of murder tomorrow, and they might be legitimately doing that. So there's an idea that states, and the political community within states have a responsibility to think about what counts as a crime in their state or what doesn't. And by redefining, whether abortion is murder or not, that I think would fall within the boundaries of state power in the absence of some federal constitutional right or some state constitutional right. So I think it's sort of the general power that states have over defining criminal law that leads to their ability to criminalize abortion in the wake of the Dobbs decision.
Yeah, thank you. Thank you for explaining that. I have another question from the Q&A. I'm actually combined two of the questions, one of which is about what about protections for performing abortion on federal property at this moment? So for example, at our VA hospitals, military bases, other federal lands, And a similar type of thinking, what about sovereign areas such as Indian reservations or, on the water? If either of you, I don't know, whoever feels more comfortable could comment on that, that would be great.
Yeah, I mean, we can both comment. I would say that there's no federal restriction other than the partial birth abortion ban against performing abortions, and the only sort of legislation would support it, right? The emergency care provisions, et cetera. So in terms of the federal government providing abortions or providing abortions on federal land, I think that's safe for the time being. Now, that might be called into question if we see a Congress in future passing anti-abortion legislation. But so far, there's no prospect of that. So abortions performed on federal land should be fine. Similarly, in waters outside of the United States, or rather waters outside of states, that's also federal jurisdiction. So federal jurisdictions are covered by federal law. State law can't contravene that. Now, I think the tribal question is quite interesting because there's a certain degree of autonomy for tribes, but even a case that was decided also around the same time as Dobbs limited that autonomy as well. So I think there's generally the power to define criminal law within the tribes. So I think probably it would be fine, but I would have to ask our other colleague, Greg Oblowski or Elizabeth Reese about the details of that.
Professor Mello, did you have anything to
yeah, so this is not an area of expertise for me, but I will say, one of the things that Professor Reese has said is that it is kind of complicated that when it comes to criminal law, there are some types of criminal law that reach into tribal property and others that don't. But that just as a practical consideration, she doubts that tribes would be interested in becoming sort of the nation's abortion providers. It shines a really bright light on a group of people who've been victimized by the federal government for a very long time and are not anxious to put themselves out there for more ill treatment.
Well, absolutely. And it's not their responsibility to solve the problems for the rest of the country when, a lot of times they don't have access to clean water, electricity, internet, et cetera. So I can understand why people have thought of that as a workaround, but there's a lot more that we need to do to support those communities rather than putting an additional burden on them in these circumstances. There are so many questions in the chat, and I'm looking at the time. We only have 4 minutes, so we're going to do the best that we can. I wanted to address something that we could do that could be positive coming out of this. So I wondered if I could get both of your thoughts on, what can we as clinicians, as healthcare workers do? And I know, Professor Mello, you had kind of mentioned to me before about things that we can do outside of the courts to restore abortion access. So if either or if both of you, and I'll go to Professor Mello first, could comment on what is it that any of us can be doing at this moment in order to help our patients access abortion. Obviously, we're somewhat protected in California at this moment, as long as there is no federal ban on abortion, although we know that that's something that they're working on as well. So Professor Mello, I'd love to get your thoughts on that.
Yeah, so I would say, number one, don't over comply with the law. Again, if you're uncertain about whether you should do something to help a patient, I think err on the side of doing it, asking for forgiveness, not permission. Because I do think a real danger here is that people will overinterpret their obligations in ways that helps the states that are trying to restrict abortions do things outside even the laws that they've adopted. So yes, legal counsel consultation can be helpful. Even just formulating a strategy as a department about how you're going to deal with out-of-state requests, for example, I think can help people feel a little bit better protected and bolder in their resistance to the law. And then secondly, I think there are a number of things that we can do to help patients in abortion restrictive states protect their health data, so that, again, not to sort of aid and abet the efforts by law enforcement to go after them by, for example, using period trackers that generate information that can be used to identify women, doing online searches outside of incognito mode or DuckDuckGo for pregnancy-related services, even thinking about what we put in patients' charts. for example, if it's somebody seen in an emergency room and experiencing pregnancy loss and don't need to record assumptions or conclusions about the reasons for the pregnancy loss. For example, the patient's seeking counseling about pregnancy termination, that doesn't need to go in the clinical notes. So I think the question to ask is what must be in the notes because it's necessary to provide high quality clinical care and support our billing. And if it doesn't, or comply with the law. If it doesn't hit one of those criteria and it's related to pregnancy, maybe keep it out. And then finally, if particularly for people who are caring for patients in abortion restrictive states, just being real careful about the paper trail that's created by email and texting. Phone and in-person conversations are still really good ways to have conversations about legally fraught issues.
Yeah, thank you. That was a great list, Professor Myler.
Yeah, so I completely concur with that. And I would just say that on a systemic level, I think not over complying is also really important. I mean, I think that Professor Miller was talking about it on a kind of individual doctor level, but I think hospitals might think about how to formulate, especially in jurisdictions like California, formulate policies that are going to not over comply with out-of-state laws in particular, and avoid enforcing out-of-state laws within jurisdictions that are still protecting the right to abortion. And in particular, one thing I wonder is about how much we need to know where someone is from when they're being treated, right? Or so maybe the doctor doesn't need to know where they're from, then they might not be subject to some kind of suit or penalty from a state that is restricting abortions. But I think that that message of not over complying, I think is really a good one that Professor Mello suggested. Thank you.
Yeah, thank you so much. I see that we are right at 9. I did want to ask another hopefully quick question that came up in the chat, which is about people who are practicing outside of institutions like Stanford. So obviously at a place like this, we have excellent legal guidance, but there are people who practice on their own or with just a couple of other folks and may not have a lawyer on retainer. Is there guidance for folks in those kinds of practice settings in terms of the things that you all just talked about? Like, what are they allowed to do? What are they not allowed to do? And so on. Is there any resources that we could share?
Yeah, I think you'll start to see more and more of these coming out. And I know there was actually even a list of bullet points that came out with the announcement for today's grand rounds of resources for patients. But I'm also sending to Dr. Salas just a quick explainer that I did with some folks from Stanford that contains links to some of these guidance documents that are useful for people to understand, trying to unpack in plain English what they might mean. I hope that's helpful.
Yeah, that's very helpful. Thank you so much. I'm gonna I just quickly put that into the chat to our communications person to send that out to everybody who's on this call. So hopefully you'll be able to see that. And I want to be mindful of time. It's 9:01. Thank you all, or everyone, for being here, and especially thanks to Professor Myler and Professor Mello. Dr. Harrington, did you want to say anything?
Well, I just want to thank our presenter and our panelists, Professors Myler and Mello. Thank you for bringing this information to medical grand rounds, incredibly important. And we hope that we can maybe get you back in the future as things continue to evolve over the course of the coming months to year. Important topics, and we want our community to be both aware but also involved. So thank you both. And thank you, Dr. Salas, for moderating.
Oh, of course. And I just see, sorry, one last thing, if I could keep you for another minute, is I think Dr. Subak was wanting to join us and make a comment. Dr. Zelga, are we able to get her on as a panelist? Just real quick.
I sent her a message, and I know she said some great comments in there. We'll have her perhaps come back another time. I don't think she's over on the panelist side, but I just thank you to Dr. Subak for everything she's been doing throughout this time.
Yeah, thank you so much, Dr. Subak, and we'd love to have you, as Dr. Zelga said, another time. Sorry, we didn't get you on here as a panelist quickly enough today. But again, thank you all for being here. And of course, this will be posted on our YouTube page within the next 1 to 2 days for sharing with whoever you think would benefit from this session. And again, one last thanks to Professors Myler and Mello, and everyone have a wonderful day.